Good afternoon or good morning for those of you out west. I'm Randy Sadler, Principal of CIC Services. I will be your host today. Our expert guest is Sean King, attorney CPA. He's the founding principal of CIC Services. He's also in-house counsel, and he has been the champion, the spearhead that has taken Notice 2016-66 by the IRS all the way to the Supreme Court, where we, with the help of many in the industry, won a 9-0 victory. Very excited about that. And recently just had another huge victory that Sean's going to talk about today. So let's dive in. Our topic today is COVID survivors, captives, the IRS, and audits. And I would ask, if you have any questions, type them into the chat bar. We will pause at times to take questions as well, and we'll try to leave time at the end for questions. I would ask, if you would, keep your computer or phone on mute unless we pause and you have a chance to ask a question. So just keep it on mute. A little bit of background. So Sean, and by the way, we'll be glad to send you these slides if you'd like them. Sean is an attorney, CPA principal in our firm. He's a visionary, always a step ahead. He got into retirement plans before they were cool. Got into captives before they were cool, and then got into cryptocurrency before it's cool. And we need to be asking him what's cool next. But Sean is a great visionary and leader, and we're very excited to have him as our expert guest today. And I'll be your host, Randy Sadler. I'm also a principal here at CIC Services. I've been here 10 years. My background is I grew up in Tennessee. Went to West Point, was a tank commander in the Army 5 years, and that's really where I learned risk management, having a responsibility for soldiers, vehicles, ammunition, fuel, and making sure no one got hurt. And since that time, I've worked in a few corporate roles, and I'm now a principal here at CIC Services, helping businesses insure against risk by owning their own insurance company. And quickly, a quick overview of CIC Services, and I'm going to bring Sean in just so you have a little background. We're a captive manager, which means we help companies set up and own their own insurance company and self-insure and tap into the benefits of self-insurance. And that really includes things like establishing asset-protected loss reserves, increasing profit and wealth, generally by millions of dollars for most of our clients, lowering and controlling insurance costs, very important. Insuring uninsured or underinsured risks, like COVID-19 being a classic, and then obviously benefiting from insurance company tax treatment where a company qualifies as a real insurance company. And a little bit more, in 2021, we won Middle Market Captive Manager of the Year for the U.S. Captive Service Awards from Captive Review. So we're very excited to be recognized for our contributions to the industry, and largely really for Sean's contribution in leading our court cases against the Internal Revenue Service. All right, so let's dive into the meat of our conversation today. And that is, if you're a COVID survivor, or if you're a business owner and you're a COVID survivor, congratulations. Isn't that right, Sean?
Absolutely. We know a lot of businesses that didn't survive. Unfortunately, some of those, or at least one or two of those, were businesses that the IRS basically extorted into shutting down their captive, in some cases, the year before COVID. So many of those businesses are really hurting today as a result. But yes, if you manage to make it, and especially if you manage to make it without the benefit of PPP funds, though we ourselves took PPP and certainly don't resent anybody who did, then congratulations. That's a huge accomplishment under these conditions.
Yeah, so what you'll notice here, and what we've got up, is that many businesses that had business interruption during COVID had their claims denied, right? And this is a recent article in UC News.
Randy, we should clarify here that you're talking about commercial third-party business interruption insurance here.
That's right. That's right. Very good point, Sean. Many businesses that had commercial third-party insurance had their COVID claims denied. You see this quote here. Many business owners have assumed that the pandemic would meet the very definition of business interruption. Unfortunately, the majority of claims were denied. Now, In many cases, this was because their business interruption was tied to property damage. And then also in many cases, they did have virus or pandemic exclusions, right? Leaving them uninsured at a time when they thought they were insured. Now, that's not the case for many who are insured by captive insurance. When you think about COVID survivors, Sean was recently published in Captive International. Sean, you want to tell us about your interview with them and what y'all covered?
Yeah, sure. So this was an article that co-written by myself and Jaina Patel, a brilliant young law student. And essentially, it was just pointing out the fact, and you can go Google this and read lots about it. In fact, there is a website out there, I forget the name of the website, that is tracking all of these, at one point, more than 2,000 different cases where insureds had sued their employers, not their employers, their insurers, for denying business interruption claims. And it was tracking the outcome of those cases. And with very few exceptions, the courts were just kicking these cases out. The policies were written so narrowly that a virus outbreak did not trigger, in the court's minds at least, coverage under those policies. So this was an article that just talked about that and talked about the importance of protecting yourself against those things and not relying on your commercial policies to do it, because they're typically riddled with those type of exclusions.
Yeah, very good points. In fact, the article highlighted 4 CSE Services clients. One was a trucking company whose city routes were canceled and their captive claim was approved during COVID, which was a big help for them. I actually talked to the business owner last week. He's thrilled with his captive. An ophthalmology practice that was closed as non-essential, big hit to their revenue. The captive paid their claim. Pediatric dentistry practice also closed as non-essential. And then employee performance consultant that ran big events, and they had event cancellation, and their captive covered that event cancellation. So these are just 4 in the story. You can actually read this story at the link provided on this page here. And so just send me a note and we'll be glad to run that by. Jaina was quoted in the article saying none of CSE Services clients who had a COVID-19 related loss went out of business during the pandemic. Now, if you think about it, at the time, CSE Services was insuring 100 businesses. So 0 out of 100 went out of business. That defies the odds, wouldn't you say, Sean?
From our experience, absolutely. Especially when you consider the types of businesses that some of those were in. They were really adversely impacted by COVID.
Absolutely. So as we think about surviving COVID, Sean, what might be next?
Well, we don't know, right? I mean, at this point, even our clients who are writing coverage through captives that we may place can't get coverage for COVID, right? It's just like, the old rule, you can't buy fire insurance on your house once the fire is already there. So unfortunately, there's not a lot that clients are going to be able to do to protect themselves from COVID if they don't already have policies in force from that provided for that. New policies are typically going to contain a COVID exclusion. But who knows what the next potential problem is going to be. There are lots of other risks out there besides COVID. There are other pandemic diseases that would typically be covered, not specifically excluded, because the fire for those has not started yet. There is legal defense coverage for situations where clients get sued. Oftentimes they'll have, depending on what they're sued for, their ordinary commercial policies through third-party insurers may not cover all of those legal expenses. There is supply chain interruption, of course, and we all know what that looks like because of COVID, but now we're going to experience something very similar because of war, right? We have ships that, for example, aren't able to go to certain regions in Asia right now because of the war and pick up oil and make deliveries, or pick up wheat and make deliveries. And you can easily imagine situations where that could extend to other regions and other products as well. There's receivables, and times of economic uncertainty, what happens when the counterparty who owes you a bunch of money goes bankrupt? That can make you go bankrupt too, especially if your counterparty accounts for, as is the case for many small businesses, 40, 50, 60, 80% of the revenue. Lots of small businesses get 60, 70, 80% of the revenue from just a few key contracts. So those are just a few. Another one is maybe reputational damage. Things can go wrong within your business that are often not within your control, that can damage your reputation. One example is we had a client who was in a Volkswagen dealership. And you guys may remember a few years ago when Volkswagen, the manufacturer, got in big trouble for supposedly cooking the books on their miles per gallon data. And Volkswagen and Audi and several other involved companies had massive recalls. Well, those dealers took huge hits to their reputations, even though those dealers weren't the manufacturer, right? They weren't the ones who cooked the books and who committed the fraud, but because they shared the Volkswagen brand or the Audi brand or whatever, they too had a ding in sales as a result. So reputational damages is another form of risk. And there are literally, dozens of others out there that most small and mid-market businesses go completely naked on. And if recent events with COVID and war outbreaks and supply chain interruptions have taught us anything, it's that going naked on some of these risks is probably not the thing to do.
That's exactly right, Sean. I just panned through a few, just got off a call today, presenting a captive insurance model to a retailer who owned retail locations and still owns them in Atlanta and Charlotte and Pittsburgh, large cities where civil unrest and smash and grab looting cost them $800,000 in claims. The insurance company paid those claims, but they've now been dropped and they're unable to get insurance at all. So they're very interested in a captive for insuring their property and their inventory, which is their lifeblood. So you see civil unrest, pollution, even things like intellectual property theft can be very hard to insure. And in the current environment that we're in globally, this is an increasingly large threat. All right, good. And Sean, this is one of your favorite charts. Tell us about it.
Yeah, so this is really important, and it's going to have some relevance when we get to the topic of the IRS, which is coming up here in just a few minutes. But the U.S. government, IRS accepted, actually wants companies to set up and operate captive insurance companies. Congress incentivizes it through the massive tax subsidy available in 831B for a reason. It serves a very important public policy objective. And that is that small and mid-market businesses in particular are uniquely fragile, and yet they account for more than half of the jobs in the country and more than half of all job growth in the country, growth in net new jobs over the last 20 years. So whereas a Fortune 1000 company could easily survive a fire at one of their facilities or hazardous material spill or release, or a terrorism incident that knocks some of their servers offline for a few days, or a utility outage in one area of the country, or a hurricane that comes through. Not true for small and mid-market businesses. As we learned over the last few years, and with Hurricane Katrina, et cetera, and Sandy and others, a singular event can, in many cases, be an existential threat to small and mid-market businesses. They are just quite simply more fragile because they don't have access to the diversified income stream that Fortune 1000s do. They don't have access to the capital and credit that Fortune 1000s do. And they're often very geographically concentrated, unlike a Fortune 1000 business. So this chart here actually comes from the government's own website, ready.gov. There's a landing page there for businesses. And on that landing page, or one of the pages under that, it talks specifically about risk management and the importance of businesses addressing all of the different hazards that you see listed here in that left-hand box. The thing about those hazards in the left-hand box is they're nearly all excluded from ordinary commercial insurance policies. To the extent they're covered by those policies, there are all sorts of little limitations and catches. For example, one of the main reasons that the commercial business interruption policies didn't pay, most of them declined to pay benefits, was a little clause in the policy that said that the thing that causes the business interruption must actually do some sort of physical harm to the property itself. Now, the insureds tried to argue that, hey, having a deadly virus spreading around my campus is harm to the property itself, but the courts, by and large, said no, and the commercial carriers got off and didn't have to pay those claims. By virtue, our clients received millions of dollars. We paid in 2020, I think, a total of around 12 or 15 million dollars in claims, most of which were related to COVID, and many of which were business interruption type of claims. So that's the advantage of captive insurance. You get to have much broader, much more flexible insurance coverage.
Outstanding. Yeah, so we've talked about COVID survivors, and Sean just went through the chart on ready.gov. This is a chart, and by the way, I'll send you the slides if you ask for them, that we commonly use that outlines many what we call operational strategic risks, where businesses are commonly uninsured or underinsured and vulnerable. All right, that brings us to part 2 of our 4-part discussion today, and that is captives. So we've talked about being a COVID survivor. So where does a captive fit in? Well, let's start with what is a captive insurance company. Sean, in layman's terms.
Yeah, in a nutshell, a captive insurance company is just a closely held insurance company. Most people on the phone here are business owners or serve business owners, so you're quite familiar with the process of setting up a new business. Well, a captive is just the same. You go and you set up a new business. The difference is that this business takes the additional step of getting licensed by a jurisdiction to function as an insurance company, not a broker or an agent, but as an actual company that will issue policies under and assume risk. So they're generally owned. They're usually closely held. So they're generally owned by the same interests that own the primary insured. So most of our clients have captives in a brother-sister structure. So you'll have the business owner that owns business A, or owners that own business A. They form business B, which is the captive that they likewise own. And then business A pays premiums to the captive in exchange for the captive insuring certain risks. Captives have been around since the 1950s in the US. They've been around in Europe even longer than that. And they typically insure risks in every industry, business, and sector today. They are really a underappreciated backbone of the insurance industry.
Yeah, very well put. So really, it's just simply a choice to own your own insurance company. And so, what do captives do? So,
they can really do a wide variety of things. It's the beauty of them is they're so flexible, but in general, they're used to replace commercial insurance. If you operate a business, you may be in one that's been paying premiums for this or that type of coverage for years without having any claims. That means that you're probably either gotten really, really lucky or are a darn good and responsible risk manager. And it might make sense in that instance to take at least some of that coverage or some of that risk, a layer of that risk, and insure it through your own insurance company so that if you continue to enjoy favorable claims experience, you reap the profits from that rather than some unrelated commercial third-party insurer reaping those profits. Secondly, is you can use it to insure what are commonly called enterprise risks. These are risks that most business owners are currently naked on. If we were to sit down with the business owner and brainstorm about what are the things that keep you up at night, and then we were to compare that list of things to the things they have insured, There's a big discrepancy there. The things they have insured are not usually the things that keep them up at night. The things that keep them up at night are usually things that are not insured at all or woefully underinsured. And we can use a captive to insure those sort of enterprise risks that just aren't economically feasible sometimes to insure in the commercial market. We can use captives to do warranties. So any business that sells warranties to the public is probably or offers warranties as part of the products they sell, is probably a very good candidate for a captive, assuming they're doing enough warranty revenue. They can take that warranty revenue, house it inside of a captive insurance company, and gain some asset protection benefits, potentially some tax benefits, and some other sort of benefits. They can be used for performance bonds. They can be used to insure employee benefit plans, including health insurance can be done, at least in part, through captives, or any combination of the above things, and actually other things also. They're just incredibly flexible tools.
Yeah, and you notice there's any combination of the above. Typically, in your larger Fortune 500, Fortune 1000 companies, they own multiple captives, and they're often creating financial silos, insuring specific things in those. But in a small mid-sized captive, it's often beneficial to blend several of these into one captive, because then we're spreading that fixed cost of the captive over, say, commercial insurance replacement, enterprise risks, and healthcare, right? Putting all those in the same captive really stretches out those fixed costs. Very good. So one of the things we talk about, Sean, is this sort of fork in the road. Tell us about the fork in the road and the conundrum that business owners face.
Yeah, well, that's just it. You know, business owners often don't give too much thought to some of these risks because when they do, they get really anxious. But the ostrich approach probably isn't, you know, the approach that's going to help give your business the greatest chance of survival. So better off actually facing these risks, getting a formal risk assessment done, which is something that we can help facilitate for most any business. And then you know what the risks of your business are. You can actually face those risks at that point, and then you have a decision. You know, do we insure all or some of these risk exposures that we're currently just buck naked on, or do we not? Or some combination of the two. You know, not every business has the premium budget to fully insure every risk. That's just life. But generally, especially if there's potentially tax savings involved, businesses can afford through a captive to insure a lot more risk than they currently are.
And that brings up the conundrum, right? If a business doesn't have claims on its commercial insurance, those premiums are a sunk cost. But if you own a captive insurance company and don't have claims, they are a
sunk profit. Exactly.
How's that the case?
Yeah, it's kind of heads you win, you know, tails somebody loses. I guess nobody really loses. So right. It's kind of heads you win, tails you win.
Exactly.
If you have a captive and you're paying premiums and you don't have claims, that profit plus potentially, if you're operating a legitimate insurance company, some tax savings as well are yours forever. That's just a sunk profit that you would never have had before. And by contrast, if you do end up having claims, well, now you've got risks insured through your captive that you didn't have insured before, and through a combination of potentially tax savings over the years and reinsurance arrangements. A large part of those claims are going to be paid either by Uncle Sam through the tax savings or by those unrelated third parties. So it's kind of a win. Tails you win, heads you win.
Exactly. So this is just a simple captive structure where a shareholder or shareholders own their business or businesses, which is the insured. They also own the captive. The business pays premiums, transfers risk to the captive. The captive issues insurance policies to the business. You'll notice that the dotted line ownerships and then the profits of both are enjoyed by the shareholders. Sean alluded to reinsurance for small insurance companies. I'm going to cover this very quickly because we want to get to our discussion on the IRS and what should you do in the event of an audit, or should an audit scare you from protecting your business with a captive? Well, yeah, there are many structures that captives come in. This is a very simple structure that many of our clients benefit from, is that they are shareholders that own their business and their captive, but then their captive is able to reinsure half of its risk into a reinsurance pool, which is much like a co-op, if you will, of other captive owners sharing risk together. This is quite powerful. And the best way to understand this would be in the event of a loss. Remember, I was telling you earlier about the business owner who has had their commercial insurance canceled because of civil unrest and looting and smash and grab, which is at least died down this year, and hopefully it stays that way. Well, let's just say they had a $400,000 loss across a few stores and they were not insured at all, right? What would happen? They would just have to eat that. So maybe wealth is destroyed. Maybe they have to lay people off, maybe close a location as an example. But if they were to have their business insured via a captive, as you see here, the captive, assuming the claim was approved and it was insured, of course, the captive would pay $400,000 to the business. The reinsurance pool would pay half of that, $200,000, and now that loss is addressed. So you can just see just how powerful a reinsurance or co-op structure like this is. And certainly in many cases, and this is worth noting, we do have clients that perhaps don't pool, but then they go out and they actually buy commercial reinsurance policies to backstop losses. So there's a lot of ways for the captive to get help when it has a loss that needs to be paid. What happens to the assets in a captive that aren't paid out in claims or expenses? Well, the owners keep all of it, right? That's the beauty of owning your own insurance company. And Sean, tell us about the taxation of captive insurance companies.
Yeah, so first, just a warning, no captive should be formed for the purpose of tax savings. There may not be anything technically wrong with that. For example, lots of businesses set up 401ks for the specific purpose of achieving tax savings, or they'll engage in other transactions that are primarily tax motivated. But in the insurance world, at least, the IRS is really hostile to captive insurance arrangements that they think were formed primarily for tax savings, and they will bend over backwards to make your life troublesome if they come to suspect that's the case in your instance. So very important. Anytime you enter into a captive transaction, it needs to be for real risk management purposes primarily. That's not to say you can't consider the tax implications. Congress offered a tax subsidy for a reason, to induce you to engage in certain behaviors that Congress thinks is beneficial for the US. So we certainly don't ignore the taxes, but that shouldn't be the primary motive behind the transaction. So with that in mind, there's really two types of benefits available for captives. One is the larger variety of captive, what we'll call traditional captive insurance companies. Now, this is true not just for captives, but really for any insurance company. Insurance companies are about the only type of business out there that get to deduct this year expenses that they won't pay until maybe 3 years from now, 5 years from now, 10 years from now. Right? Every other business only gets to deduct its expenses as those expenses come due. But in the case of insurance companies, they get to actuarially forecast what their future claims are going to be. And they get to set aside a reserve on their books today to back those claims. And subject to certain restrictions and limitations, setting aside that reserve is a tax deductible expense. So this means that effectively they're able to defer taxation somewhat indefinitely, as long as the company stays around and keeps insuring risks, on a considerable portion of their revenue and profits. Now, there's another variety of insurance company, the small captive insurance company. These are companies that would meet the criteria under Code Section 831B. That is, they are companies that take in less than $2.4 million per year of premium income. They insure primarily property and casualty risks and other approved risks, and meet a few other criteria. But assuming, including being a legitimate bona fide insurance company, and assuming you meet those criteria, though, Any premiums paid to your captive for risks that are real and relevant to the business are deductible, just as if those premiums have gotten paid to State Farm or Lloyd's of London or whoever. But the captive takes those premiums in a 0% tax bracket. Under 831B, these companies pay ordinary income tax on their investment earnings, but they don't pay income tax on their underwriting profits, that is, on premiums received less claims paid. So extraordinary potential tax savings. We're talking potentially, $1 million to $1.5 million in potential tax savings if you're maxing out at the 2.4 million premium level, which is why you can understand the IRS has so much heartburn over these things, which we'll talk about in a minute. Anytime there's potential tax savings on the books, especially this massive, there are some people out there gaming the system, and the IRS wants to sometimes lump everybody into that same bucket, which is, we'll talk more about in a minute. But the potential tax savings are extraordinarily significant for insurance companies that are set up and operated in a bona fide way.
Yeah, absolutely. And these are some of the benefits of owning a captive, Sean. I won't read these out, but again, we'll send you the slides. Very, very powerful reasons for small and mid-sized companies to act in their own self-interest and protect themselves with a captive. And it really is the best approach to avoid being a victim of COVID-2, the sequel, whatever that might be, because you have more insurance and more money. So let's talk about the IRS.
Yeah, so the IRS has long been hostile to captives. This is probably the most important thing that I would emphasize. We're hearing, you might hear more and more in the news, especially if you're a captive owner, you follow the captive industry, about IRS attacks and scrutiny against captives. The important thing to understand, this is nothing new. The IRS began viciously attacking captives in the 1970s. That's the bad news. The good news is they lost effectively every single court case of consequence during that period of time. They lost in 1989, Humana versus Commissioner. 92, they lost Harper Group versus Commissioner. 2001, they finally kind of threw in the towel and offered up in 2001 and 2002 a few revenue rulings to kind of provide some safe harbors in light of those court losses. That moved forward until the mid 2000s or so, and they began to attack a number of other cases that we'll come back to here in just a minute. But in the meantime, they passed the PATH Act. Now, this is important because they lobbied Congress hard to clamp down on captives, to shrink the perceived big tax loophole. And what did Congress do instead? Well, it did a couple of things to make the loophole available to a smaller number of people. But to the people who continued to qualify for the taxes, Congress actually increased it, and by a lot. The premium limits under 831B went from 1.2 million per year, where they had been ever since 1986, up to 2.2 million per year, and then adjusted for inflation periodically. So that number is today 2.4 million per year maximum premium income. So Congress scrutinized it. They heard the IRS's whimpering and whining, and still made the fundamental policy decision that captives serve an important public policy purpose, and we need to continue to incentivize them by making the tax deduction potentially even larger for the businesses that do qualify for them. In 2016, the IRS started getting really pissy. They were not happy with the outcome they got in Congress. And so they decided to basically double down on a campaign of terror. They decided that if they couldn't achieve through the courts, and if they couldn't achieve through Congress what they wanted, that they would instead try to terrify taxpayers, and more importantly, advisors to taxpayers, away from captives. And they did this in a couple ways. One is through a FUD campaign. trying to spread fear, uncertainty, and doubt about captives, about what a legitimate insurance company is and isn't. If they can shroud that bright line, that cliff, in a big shroud of fog, then they know that taxpayers and, more importantly, their advisors are going to steer well clear of that cliff, which was their goal. In other words, they just wouldn't do captives at all. And then they also made captives a transaction of interest in Notice 2016-66. We'll talk much more about this in a minute, because just 3 days ago, thanks to a lawsuit that we personally brought against the IRS, a federal district court just vacated Notice 2016-66 as being illegal, because it was illegal. So we'll talk more about that in a minute. In 2017 or so, though, they did start to win a few cases involving small micro captives that had been not operated particularly well. They had some bad fact patterns. They won a case in the Avrahami case where the captive had loaned 80% of its assets back to the business owner. The captive had never paid a single claim in the history of the captive. Really only one type of risk, terrorism risk, was pooled, and it was a terrorism policy was written in such a way that there had never been an event in the history of the world that would have triggered coverage under that policy. And yet the premium for that policy was like $360,000, quite a bit. So taxpayer lost that case, not a big surprise. In the next year, they managed to win another one, Reserve Mechanical. This one is actually on appeal, so we'll see what happens on appeal with Reserve Mechanical. That case is a little more complicated. I'm not sure the tax court got that case right when they ruled for the IRS. At least I don't think they got it totally right, but we'll see what the appeals court says on that one. In 2021 and 2017, actually, we sued the IRS with regard to Notice 2016-66. It took us up to 2021 to finally make our way up to the Supreme Court. The United States Supreme Court agreed to hear our case, CIC Services versus Internal Revenue Service. And in May of last year, we won 9-0. It's very rare to get 9-0 decisions out of the Supreme Court these days. But we won our case against the IRS 9-0. Basically, the Supreme Court said that if Notice 2016-66 was passed illegally by the IRS, as we contended it was, that the district court, despite its prior determination to the contrary, did have the authority to vacate or overturn that notice and make it null and void. That brings us forward to 2021. We are finally starting to get some good court cases now. We saw where the IRS won Avrahami, they won Reserve Mechanical. They also won a couple other crappy cases after that. But we're finally getting some really good ones now to the point where they're ready for trial. One of them was Puglisi Farms. Now, the problem is the IRS doesn't want these good captives going to trial. So what they do is they are treating, unfortunately, a lot of captives the same. They're not making any good faith effort to distinguish the good from the bad captives. They're saying pretty much all of these are bad, and they're assessing taxes, back taxes as a result. Some taxpayers are settling with the IRS just to get them out of their life. But some smart ones like Puglisi Farms are giving the IRS the finger and say, we'll see you in court. And Puglisi Farms did that, went to court. And in fact, in that case, the day before, I believe the case was to start trial, the IRS completely threw in the towel. They rolled over, agreed to refund all of the clients' money and dropped their claims against Puglisi Farms. So it goes to show you that if you're willing to stand up for or against the IRS, I should say, and you have a legitimate captive, you can, in fact, win. And we are expecting to see many more of those sort of rollovers from the IRS in coming months. We're already aware of at least one or two more. And I think we will actually get some cases tried and get some taxpayer victories here in the next 2 or 3 years that will also put the IRS back in a more reasonable box. And then in 2022, I just mentioned earlier, just 3 days ago now, the U.S. District Court for the Eastern District of Tennessee vacated Notice 2016-66 on the grounds that it violated the Administrative Procedures Act, and very importantly, that it was arbitrary and capricious. Now, for the court to find that that notice was arbitrary and capricious, the court had to find that after 5 years of litigation, during which the IRS had every opportunity to put all of its cards on the table and prove why it was attacking captives or 831B electing captives, for the court to conclude that that notice was arbitrary and capricious, it had to find that there was no reasonable basis in the administrative record after giving pretty much all reasonable doubt possible to the IRS that would justify the notice. In effect, the court said, we cannot find any evidence in the administrative record that would support the IRS's conclusion that captive insurance companies were being used abusively in tax avoidance transactions, and that would therefore justify imposing the obligations of Notice 2016-66 on taxpayers. So that has been vacated. And it is now, as we sit here today, confirm this with your own advisors, but our understanding that it is no longer enforceable against any taxpayer or any material advisor anywhere in the country. And additionally, the judge ordered the IRS, in an attempt to protect taxpayers, to return from whence it came all data and information that the IRS illegally collected by virtue of Notice 2016-66. So we will see if and how long the IRS will take to do that. My guess is they'll drag their feet out to take a decade to do it. But we'll certainly do our best to keep the heat on them and try to make sure that happens in a reasonable amount of time. There's a question that popped up: is the ruling just for one district or just one circuit? No, the court vacated the ruling, the notice. So it's not something that's limited to a particular circuit or what have you. Under the Administrative Procedures Act, that is the appropriate remedy when an administrative agency violates the law. The appropriate remedy is to vacate that, and that vacature applies, our understanding, confirm it with your own advisors, to all taxpayers everywhere in every jurisdiction, including their material advisors.
Yeah, and Sean, we got another pop, a little bit different. Does this apply to all transactions of interest?
No. Well, transactions of interest are can be anything. They can be captive insurance companies. They can be anything else that the IRS has designated. So technically, this ruling only applies to Notice 2016-66, which involved captives. But if the IRS has by notice designated other types of transactions as transactions of interest, or as reportable transactions, or as listed transactions, and they didn't follow the requirements of the Administrative Procedures Act, then taxpayers can and already are bringing separate lawsuits to have those notices overturned also. So this could have some significance, for example, in charitable easement cases, and maybe some others also.
Very good. All right, so we talked about this slide used to be what is IRS Notice 2016-66. I've put it in the past tense. What was it? Sean defined what Notice 2016-66 was. Anything else to add on this, Sean? You think we've covered enough?
No, I just want to emphasize just how abusive the IRS was here. The law is very clear, as evidenced by a 9-0 Supreme Court decision. You know, it wasn't even really a shade of gray when you get all 9 justices, regardless of party affiliation and persuasion, on the same page. The law was really clear that the IRS, which is an administrative agency of the executive branch, is required to follow the Administrative Procedures Act when it passes a regulation. Now, a regulation under the Administrative Procedures Act, doesn't matter what you call it, a notice can be a regulation if it imposes any substantial obligation or burden on the public. So clearly, IRS Notice 2016-66 did that. It required, under penalties of criminal sanction and $50,000 fines per violation, every person who had engaged in one of these transactions and every material advisor to such a person to file ridiculous amounts of information with the IRS. And so that's clearly an obligation. The IRS made this by edict, just announced it on November 1, 2016, without following any of the required procedures of the Administrative Procedures Act. They gave no notice, no comment, etc. And we now know they did it completely arbitrarily and capriciously, meaning they had no rational basis for doing what they did. They did it purely, in our mind, and I think it's pretty clear now that the court has all but agreed with us. They did it simply to harass taxpayers and material advisors and to terrorize them away from captive insurance companies because they had been unable to get the courts to do it, and they had been unable to persuade the Congress to do it. So they had tried to do illegally what they were unable to accomplish legally. We've now held their feet to the fire on that and plan to continue to do so. So we'll keep everybody posted on how that exactly turns out. The IRS could appeal. The Sixth Circuit is not going to be sympathetic to them. Just a few days before the district court ruled in our favor, the Sixth Circuit ruled in the case called Mann Construction that was directly on point, and that just cinched our case for us against the IRS. And so with that Mann Construction verdict, appealing to the Sixth Circuit is not likely going to do the IRS any good, but they might do it anyway, just because that's who they are, and they have unlimited amounts, despite their whining to the contrary, of government money to waste, trying to harass taxpayers into complying with what they want, what they think the law should be, instead of what the law actually is.
Yeah, federally funded extortion of the taxpayer. So Sean, we do have a question here. Since this is a TOI, transaction of interest, does the 8886 still need to be filed?
Yeah, consult your own tax advisor about that, but our understanding is no. The notice, the only reason you ever had to file the 8886s was by virtue of this notice, and this notice has been stricken. It's null and void, as if it never existed. It is illegal and unenforceable by the IRS. So again, confirm this with your own tax advisors. We can't be your legal counsel on this, but no, you shouldn't have to file 8886s or otherwise comply with any of the requirements of form of notice 2016-66 from this point forward, or from 4 days ago forward.
All right, so we've got thank you with 3 exclamation points. Very nice. Okay. You're welcome. Very good. Let's keep move through a couple more slides here. So Sean's already covered this, but we call this supreme result. Any extra commentary on the Supreme Court case that's worth sharing, Sean?
No, I think we've covered it. It was a very important case. It set a big precedent that the IRS hates, and so I guess my one piece of commentary is that the IRS is actively trying to persuade Congress to legislatively overturn our 9-0 victory in the Supreme Court. Mm-hmm. They are trying to get Congress to reinstate their ability to rule by fiat rather than having to follow the requirements of the Administrative Procedures Act, and to insulate them from legal challenge through another act that's called the Anti-Injunction Act. So it's really important that we not allow the IRS to continue to abuse taxpayers. And the only way we can do that is to make sure that Congress doesn't undo all the hard work that we've done. So with that in mind, we have been and will continue to keep you informed through our Captivating Thinking newsletter and other ways on this topic. And we invite you to please contact your senators, contact your congresspersons. We provide a specimen letter for doing that, and just make your displeasure with the IRS abuse clear. Again, the fact that the district court ruled that the IRS behaved arbitrarily and capriciously proves that they had no sound, honest reason for engaging in the conduct that they did, and under threat of massive penalties and even prison time, forcing thousands and thousands to spend tens and hundreds of thousands each complying with this stupid notice 2016-66 that was never legal from the beginning.
Yeah, and you know, the IRS is going to go to Congress and ask for Gestapo powers. So, you know, at the end of the slides here, we'll provide contact information. Sean is part of the lobbying effort and organizing an effort to get the message to Congress not to give the IRS the ability to abuse taxpayers. I'd love to have you all join that as well, and we'll talk about how you can do that here at the end. So we've got the Supreme results. Obviously, we talked about that. Sean, we do have a question. Do you anticipate a motion to suspend the district court ruling pending appeal?
I think that's probably a decent likelihood. There's zero chance, I think, that would get granted. The IRS, again, has unlimited amounts of money to waste, making us spend money, which is their goal. And so, yeah, they're going to file, I think, pretty much every motion they could possibly think of just to make us have to spend money resisting it. But I don't think they stand any significant chance of getting a stay on the enforcement of the district court's ruling pending appeal, especially in light of the Mann construction case. The law and appeal is just perfectly clear. The one thing the IRS might win on appeal was the district judge's ruling that they return all the data they illegally collected. The Sixth Circuit is not going to overturn the district court's vacatur of 2016-66. It is gone. But they may say that the IRS, it's too much to ask the IRS to have to return all the data it illegally collected. I don't think they would agree to even that, but they might. So for that reason, the IRS might petition for a stay. The stay won't be granted, I don't think. I'm real sure. And then the Sixth Circuit might hear their case, or would hear their case, and I think would almost certainly uphold the district court's decision, with the possible exception of requiring the IRS to return the illegally collected data.
All right. So Sean, that brings us to a really important question. I mean, you know, should fear of an audit stop a business owner or business owners from acting in the best interest of their businesses and their employees? How should we think about this?
This is what is so terrible. This is what, I get red-faced when I think about it. The IRS has, as part of this terror campaign, been on an audit rampage of captive insurance companies. And like I said earlier, they have not made any honest effort to distinguish legitimate captive insurance companies from bogus ones. They literally have a template notice of deficiency, and they pretend to conduct an audit, and then they issue their template cut and paste notice of deficiency. And it's laughable, because many allegations, it's just a cut and paste allegation of deficiencies that don't apply to a particular taxpayer. For example, in the cut and paste allegations, it typically says the captive has never paid any claims. That's one of the standard allegations. We've seen that a dozen times or more now. In fact, in one instance that we're familiar with, the captive had paid lots of claims every single year, including claims to unrelated third parties, and had paid a $600,000 claim to itself in the very first year of its existence due to a loss of a key customer. So, it's just not a good faith audit effort by the IRS. And in light of that, they have managed to terrorize a lot of clients into settlements, clients who just didn't have the stomach, like Plupisi Farms or like CIC Services, although we weren't audited, we fought them in a different context, to go to battle with them, to go to court and to prove your case and to win it. And so, as a result of that, we did see in the 2 or 3 years prior to COVID, we probably lost 30 clients who, not necessarily as a result of audit, but at least as a result of Notice 2016-66 and the hassle it created, as well as all the IRS FUD and their dirty dozen listing and everything else, chose to wind down their captives just before COVID hit. In one instance, there's a equestrian hospital. They work on world famous racehorses in Ocala, Florida, one of our clients. And this equestrian hospital shut down their captive the year before COVID, and then had a $500,000 loss that would have been covered the very next year had they kept it in existence. So it's terrible. And the short answer is no. You should not allow IRS extortion to keep you from doing what's in your best interest and what Congress is specifically trying to incentivize you to do. And we're going to do our best to have your back, and lots of others are also, hopefully. So please don't let the IRS overly influence your thinking. Do a captive, do it legitimately if it's appropriate for your business, and get a tax opinion if you need the protection of a tax opinion to boot.
Yeah, so that kind of brings us to the conclusion, Sean. I mean, the best approach to avoid being a victim of COVID-2, the sequel, whatever that might be, a pandemic, civil unrest, war, electromagnetic pulse, who knows what it could be. The captive provides more badly needed insurance and more money. And, obviously there's a momentum against the IRS, and hopefully it will continue. So any questions? We'll right at an hour. If you'd like a copy of the slides, just send a note to either Sean or me. We'll be glad to send those to you. And we've just got a question in the chat bar. Let's see what that question is. Oh, great presentation. Thank you. Absolutely. Another thank you. Thank you, Randy and Sean, for the presentation. Update on current developments. That's from Paige Roble. Thank you, Paige. Andre Payne says, great presentation. Thank you, guys. Really appreciate everybody tuning in today. Great questions and for a great presentation. We'd be honored to work with you. I did mention the lobbying effort that we're part of as well. If you would send Sean or me an email and ask to be part of it, we'd ask for small financial support. But we're trying to put together a wide range of businesses, financial advisors, captive managers, really to lobby Congress to ensure that the IRS does not get Gestapo powers, but in fact continues to be under the rule of the Administrative Procedures Act, like Sean talked about today. Thank you so much for coming today. It's been an honor to have you all join our webinar. And again, we'd be honored to speak with you one-on-one. Everybody have a fantastic rest of your day.